Hello and welcome back to In Your Defense. I'm attorney Steve Tolan. Today we're going to continue our discussion on search warrants, and we're going to talk about now the execution of a lawful search warrant. What must be done and how must the police act or behave when they're on your property in the execution of what we hope is a lawful search warrant, right? So we know what it is and we know what must be included in this affidavit. Now, how do the police need to go about it? First and foremost, 4 rules to remember. The first one is, generally in Texas, the rule is they must knock and announce and then provide a copy of the search warrant to the landowner. Now, if something changes and they don't do that, there are exceptions to that rule. They would need to articulate why, and we'll talk about that in a moment. That's the general rule. They need to follow that. Second rule to remember is that no-knock search warrants, where they don't knock and announce, but they just barge in, like what happened in the Breonna Taylor case, while those are generally deemed to be unreasonable outside of some specific reason articulated to the contrary, they are legal in Texas. So 2 ways that can happen. First is in the swearing to the facts contained in the affidavit for a valid search warrant. A law officer could say, look, Judge, here's why we think we need to do a no-knock. We think the evidence will be destroyed. We have reason to believe this is the specific evidence we're going to find. We kind of know exactly where it might be, etc., right? They state a specific reason. Or it'd be futile. It's going to be super dangerous. We've been working on this, Judge, for quite a while. We have a SWAT team organized. This is how we're going to do it. So they need to state a specific reason. However, if they go and they don't state a specific reason and they're going to do a knock and announce and then all of a sudden it turns into a no knock and announce, so they just barge in, that still can be deemed lawful. However, the officer would have to explain, if questioned later in a hearing through an exclusionary rule, motion to suppress, etc., the officer would have to articulate what changed, what was different once they got on scene that made them feel like, for safety reasons, etc., that they had to do a no-knock instead of a knock and announce. So that is still the law in Texas. There is law put forth, there is proposed legislation, to change the law on that. But that is still the law right now, that no knocks are allowed in Texas. Third thing to remember is that officers do need to stay inside the scope of the search. So once they get there, they're allowed to go in all areas that are reasonable in fulfilling the objectives of what's in the search warrant, but they can't go in other places that aren't defined. So, if they didn't ask to search your car, they can only search your house or things like that, or they can't search your business if they can only search your house, etc., etc. Okay. Fourth thing to remember about search warrants and the execution of them in Texas, there is some time requirements here. So they have 3 days, and that's why, and we talked about at the beginning, that there's a specific date and the time that the magistrate signed the warrant. So it's 72 hours from that time. Now, if it's DNA that's going to be searched, well, then you have 15 days, officers do. And then if it's computer data that's stored on an electronic device of some kind, obviously hardware on a computer, then that's going to be 10 days. So generally, those are your timelines to think about. If you have any questions about search warrants, you've been served with a search warrant, or you've been arrested or charged, and a search warrant is at issue in your case and you have questions, reach out to me, attorney Steve Tolan. I'm glad to help you through that. Or reach out to us here at Peek & Tolan. And we'll continue our series of In Your Defense, finishing up on how to exclude evidence if a search warrant is unlawful. Thank you.